The trial of female footballer Sam Kerr is underway in a London court. The Matildas captain is charged with aggravated racial harassment stemming back to a cab ride in early 2023. During this particular cab ride, one of them vomited in the back of the taxi and refused to pay for the clean-up. When an argument ensued, the cabbie called the police, who advised him to come to the nearest police station. On arrival, the police saw Kerr climbing out of the smashed back window of the taxi. Later, the player alleging that she thought they were being taken hostage. The court will decide whether the Matildas captain is guilty or innocent, as the jury sees fit. But there are also questions for Football Australia, such as, will Sam Kerr captain Australia again, regardless of the outcome of the court case? It's a question I put to the interim coach of the Matildas today, who gave a press conference announcing his squad for the upcoming She Believes Cup, to be held in the USA later this month.
That's a good question. It's difficult for me to answer that, to be perfectly honest. I think obviously with the court case that's going on at the moment, it'd be unwise of me to sort of comment on that and comment on the outcome or whatever that outcome might be of that. So I think it's a case of waiting to see what happens and then move on from there. You know, from a football perspective, my main aim as the head coach is hopefully to have Sam fit and healthy in as quick a time as possible. I saw some video of her last week and she's running pretty strongly. So, you know, from my perspective, I'll let this process take its course and then we'll look at what we do after that.
And from your perspective, is there a set of standards that players must meet above and beyond to fill the role of the captain?
That's a good question. I honestly I don't know the answer, the complete answer to that, to be perfectly honest, Tracy. As I say, I hadn't even thought of that scenario at this stage, because my main scenario, first and foremost, is to, apart from knocking things over, is to look at this squad for this tournament and focus on that. And with regards to Sam, my main scenario is hopefully that she gets back to good health as quickly and as safely as possible.
Should captains of national sporting teams be held to a higher standard? What does it say when you think about the impact of a captain's role on the rest of the team and standards that are acceptable or not? And would we be judging these standards differently if we were talking about the captain of a men's team, the cricket team, the rugby league team, or the Socceroos, for instance? And does footage like we've seen overnight from the court case impact on the broader brand of a team like the Matildas?
Honestly, you guys are f***ing stupid and white.
Okay.
I'm looking you in the eyes.
Why are you
I'm
bringing
looking you in the
racism?
eyes. Like,
So-
that's f***ing stupid. I'm f***ing over this. This is the world f***ing problem.
In court, Kerr's lawyer, Grace Forbes, said this: "When you look past the headlines at the evidence, Kerr did not feel hostile towards this officer because he was white. The words were a comment, however poorly expressed, about positions of power, about privilege, and about how those things might colour perception." Now, power and privilege are debatable concepts. For instance, where does power and privilege lie if you happen to be comparing something like a constable earning $110,000 a year to walk the streets unarmed, or an internationally renowned football star who earns about 30 times that amount with an army of legal experts at her disposal? It emerged in court that when Kerr was asked whether she would pay for the damages bill to the cab, she said, "Many are asking whether an Indian woman can be found guilty of racially harassing a white male." Well, this is what the law says in Great Britain, according to Max Hill KC, who was the former Director of Public Prosecutions. I asked him about this when the Kerr case first emerged about a year ago.
Sure. And let me say as we start this discussion that I can't talk about a live ongoing case. And I know there's interest in a particular case which is live in England. I'm not going to talk about that, but I can talk about the legal principles. And in our jurisdiction, England and Wales, and it's, in common with many other jurisdictions, we have public order legislation. And in our case, that's been on the statute book, passed by our Parliament since 1986. And that deals with causing harassment, alarm, or distress. That is the technical term. And the way in which a person causes harassment, alarm, or distress was amended in 1998 by a Crime and Disorder Act to say that if that's what you're doing, and you can do that by words or by physical conduct, and when you do that, you are doing it in a way that is racially or religiously aggravated, then it's a slightly more serious offence. And racial aggravation means that you are, in, let's say, the words you use, demonstrating hostility towards another person based on their membership of a racial group. And there are many ways in which that can be committed, but that is the aggravated offence. So it's still a public order offence, but when it comes to conviction and then sentence, there can be a slightly more serious sentence.
And in that regard, because there can be a slightly more serious sentence, how is that determined? Is it a higher bar that it has to pass?
Well, I think what happens is that if you imagine causing harassment, alarm, or distress to somebody in the non-aggravated standard offence, then our lower courts, our magistrates' courts, can deal with that very, very often without even considering imprisonment, but they can impose prison sentences up to 6 months. The difference for the racial or religiously aggravated form of that offence is that, again, that can be dealt with in a whole host of ways, usually in our lower courts, usually in a non-custodial way, but it can, in the most serious cases, go up to our serious Crown Court, and a sentence of up to 2 years can be imposed. So it just gives much more flexibility to courts in how to approach it. And the way they'll approach it is based on the seriousness of the incident itself. So they'll be guided by the facts, which, if we're talking about a conviction, they've decided are true facts. And then they will look at all the surrounding circumstances, including, of course, the character of the person who has been found guilty of this offence. In the very worst cases, with many previous convictions for this offence or other offences, you can see that this could pass what we call the custody threshold, and courts will start to think about prison sentences. In other cases, it won't come close to that. It's a conviction which we marked in some lesser way.